Well, good afternoon. Thank you, everybody, for coming to the final round of New York Law School's 34th annual Froessel Moot Court competition. My name is Cambridge Peters, and I am the chair of the New York Law School's Moot Court Association. It is my pleasure to welcome you all to watch the final four competitors in this year's Froessel Moot Court competition. New York Law School Moot Court Association is one of the largest student-run moot court associations in the country. And the Froessel Intramural Moot Court Competition is one of the largest intramural competitions in the nation. This year's competition was rigorous with over 100 competitors, and everyone who participated should be very proud of themselves and deserves a round of applause for all of their hard work. As a member of the association, it has been my pleasure to watch the competitors compete and excel in both written and oral advocacy. It is my pleasure now to introduce the final four competitors. Justin Astenfelter as Petitioner 1. Brian Dolan as Petitioner 2. Gaurav Dave as Respondent 1. And Gretchen Jenkins as Respondent 2. And now I will turn it over to our Vice Chair, William Dax, who has been an amazing partner and support system throughout this process. He has been behind the scenes and helps keep everything run smoothly throughout the year. He, along with Matthew Dubroff, our Alumni Relations and Media Chair, have literally been locked upstairs in the office for the past week, tabulating and calculating all of your scores. So they deserve a round of applause for all of their hard work. And without further ado, William Dax.
Thank you. Hi, everyone. Just bear with me. We have a couple of thank yous and congratulations to go through. First, I want to start off and first and foremost thank Dean Matisar and Dean Buckler for their continuous dedication and support for the Moot Court Association. We also want to especially thank Professor Abraham, our faculty advisor, who has provided assistance and guidance all throughout the year to each one of us on the association. We also want to extend a special thanks to our professors and our faculty who have judged rounds and have helped evaluate the numerous amount of competitors that we've seen this year. And now to my colleagues. We'd especially like to thank the Froessel co-chairs, Bobby and Dina. They've spent countless hours and days making sure that Froessel has been a professional and yet smoothly run competition, and they've been great this entire time. We'd also like to thank the authors, Andrew and John. For providing such a challenging and interesting fact pattern while still making it funny at the same time, and the subsequent bench brief, which was a meticulous process. Both were dedicated to producing quality, and it really showed. We would also like to thank the editors, Allison and Chris. Who both edited and proofread the fact pattern and the bench brief and made sure that everything was ready to go before it was released. And finally, I'd like to thank, once again, Matt, our Alumni Relations Media Chair, who, along with myself, was up in the office tabulating all of your scores. And he's been pitching in for numerous other tasks, so he especially deserves a thanks for his help. And finally, we also want to thank the numerous amount of NYLS alums that come back every year for judging and just continuing their support for the Moot Court Association. So we especially want to give a thanks to all of them. I'm now going to turn it over to Bobby and Dina, who are our Froessel co-chairs.
Well, hello, everyone, and welcome. I'm continuing the welcome train here. My name is Dina Cromaldi. I'm one of the co-chairs for the Froessel competition. My first thank you is to my co-chair, Mr. Pavchek, who took on an enormous task of managing all of the competitors. We had over 100 competitors this year. This was a huge undertaking, and he did a fantastic job. I think he deserves a round of applause. We would also like to thank Professor Abraham as well. I know Mr. Dax had mentioned her, but she has been such an amazing mentor to both of us and what a fantastic support system, so I wanted to say thank you to her as well. Also, we'd like to thank Sanja Davis, who was a wonderful support to the Moot Court Association. Unfortunately, she's a little under the weather, so she's not here with us, but I wanted to say thank you, Sanja. Hopefully she can hear me, at home. We would also like to thank Jessica Aviles, especially. She is the events coordinator here at New York Law School. This was a huge undertaking this year. We had an enormous competition, and without her support and dedication and encouragement and coordinating everything, I owe you such a thank you. So thank you so, so much. We'd also like to thank the AV department for our fantastic technology here and the OIT department for all of their support. We'd like to thank the security staff for being so compassionate and so flexible with us as we had so many judges coming in and out of the building, driving them crazy. We appreciate it so, so much. And we'd also like to thank the catering staff as well for being so fabulous and so supportive. So we appreciate everything, everyone. Thank you for helping us make this competition, I think, the best ever.
I just want to echo exactly what Dina said. I want to extend a huge thank you to Dina for being such an amazing co-chair as well. As she mentioned, this was one of the largest competitions we have ever had, and being able to pull in as many judges as she did, and the level of judges that she brought in to accommodate this large group was incredible. And and without being too repetitive, just a thank you to the rest of the e-board and the association in general. We asked a lot of them in this competition to be able to accommodate this big group. Just going to go over, I guess, the sort of the process for this competition and where sort of the original history of this competition. The namesake is Charles W. Froessel. He's a distinguished alumni of New York Law School and a tireless public servant to the state of New York. Some of the roles he played in the state of New York: he was a sheriff of Queens County, assistant district attorney in Queens County, special assistant to the U.S. Attorney General, and also a justice of the of the Court of Appeals of New York as well. With everybody here, the namesake of this competition, Charles Froessel, would be very proud of this this group that we had today, and through the last couple days, even all the way through. The competitors that are before you and all of the team members here and everybody else went through an extremely rigorous process to get where they are right now. Just a brief overview of that for those who weren't involved. The competitors submitted a written brief that was turned in at the midway point of August, about a month ago. And then starting on Wednesday, we started the rigorous preliminary round oral arguments. Each of these competitors argued on Wednesday and Thursday. Then we made a cut down to the top 64. That was a giant cut, and it wasn't an easy cut because there were so many great competitors. From there, it only got harder. We made a cut Friday morning after a couple more rounds of arguments down to the top 32. Then from there, some of those people had to turn right around and argue again that afternoon. And at the conclusion of that day, we selected our top 16 advocates. Those competitors were automatically granted membership to the association, and that round was remarkably close when we were looking at tabulating all the scores. Saturday morning, we cut down to the top 8, and at the conclusion of the 12 o'clock round yesterday, we have our top 4 in front of us today. Everybody involved knows just how intense this competition was, just how difficult it was, sometimes going back to back with different issues. So again, I just want to extend a thank you for the hard work to everybody who was involved, and an extra great job to this top 4 here.
Okay, so now we'd like to introduce our fantastic Dean Matazar, to please come and join us. He will be introducing our final round bench. While he's making his way up here, we just wanted to extend such thank you and our deepest gratitude to you for not only being one of our judges on our esteemed final round bench, but just for being such a fantastic support to the Moot Court Association. We appreciate it so much, and thank you so much.
Thank you all. Afternoon, everyone, and welcome to Sweetwater versus Dubrop and the final judges for the panel. I will be one of the final judges. My bio is I grew up. You know the rest. Okay. George Bundy Smith. George Bundy Smith has served as Associate Judge of the New York Court of Appeals, our highest court, for 14 years, from 1992 until his retirement in 2006. From 1987 to 1992, he was Associate Justice of Supreme Court Appellate Division, First Department. From 1980 to 86, Justice of the Supreme Court of the State of New York. His judicial service began in 1975 when he was named to the Civil Court of New York City. Judge Smith has served as an adjunct professor of law at Fordham University Law School and has also worked at New York Law School as a professor in the year 2001. In the earlier part of his career, Judge Smith worked as an attorney for the NAACP Legal Defense and Education Fund, and it's important to note he was one of the real pioneers within that field. He has worked throughout the state of New York in various capacities and currently is a partner at Chadbourne and Park in the firm's litigation practice. Jed Rakoff is the United States District Court Judge for the Southern District of New York. He also seems to be teaching at Columbia Law School, which is our parent, as you know, a little bit up the one. We like it better than downtown. He also served as a law clerk at the Honorable Abraham L. Freedom, the United States Court of Appeals for the Third Circuit, and as Assistant United States Attorney for the Southern District of New York. Judge Rakoff has authored 5 books, published over 100 articles, written over 600 judicial opinions, and has given over 275 speeches. He received his J.D. from Harvard Law School in 1969, his B.A. from Swarthmore College in 1964, and a master's in philosophy from Oxford University in 1966. Brooks Smith of the United States Court of Appeals for the Third Circuit is another one of our final judge panelists. He was nominated for the Third Circuit by President George Bush September 10th of 2001, and previously he served as the Chief Judge of the United States District Court for the Western District of Pennsylvania. Judge Smith was appointed in 1988 by President Ronald Reagan, and he served on the Western District until his elevation to the Court of Appeals. The final of our judges is Professor Susan Abraham. Susan is an associate professor at the law school, and she teaches evidence, advanced appellate advocacy, and principles of legal analysis, and for today's competition, most importantly, is the moot court advisor. She's represented indigent criminal defendants in New York and in New Jersey, both in trial and the appellate level, arguing many times in the intermediate and highest courts, as representing clients in disability discrimination, employment, criminal, pension, and other matters. She earned her BA from Oberlin College in 1977, her JD from Rutgers Law School in 1983, and received an MFA in creative writing from Warren Wilson College in 1991. As many of you know, Professor Abraham is a published poet as well as an outstanding law professor. So on behalf of all of us at New York Law School, I want to welcome all of you to today's competition. To those of you who participated in this competition and did not make it to the finals, congratulations for your strong efforts in participating, and congratulations also to beginning your steps as an appellate advocate. To the board, fantastic job as always. To our authors and to the case editors, you've done a terrific job on pulling things together. I think you represent the best that we have to offer, and I truly look forward to working with all of you in the years ahead. So congratulations again, and with no further ado, we're going to get on with the competition.
Good afternoon. Thank you for all coming. My name is Andrew Blancato, and along with my co-author John Hay, we were responsible for writing the fact pattern for the 2010 Froessel competition. We're going to go through a recitation of the facts for those of you who were unable to receive a copy of the bench brief or the fact pattern. But until then, we want to reiterate some of the same thank yous and mention some new ones. First and foremost, we'd like to thank our constitutional law advisors, Professor Strawson and Professor Boddy. Without their help, this would kind of be just a fantasy loosely based on the movie The Big Lebowski, not really grounded in any law. So we really extend our thank yous to them. We also want to thank Professor Abraham. Her attention to detail and just her knowledge really made this the fact pattern it is today, and we really, really cannot thank her enough. We also want to thank our wonderful editors, Allison Quine and Christopher Arco. Their painstaking attention to detail really made this fact pattern come to life, come to fruition. Without their help, we could not have done it. So on to the facts of the case. Adventures in Chbosky Land is a popular video game which is played over the internet. It features main character Jeffrey Chbosky as a local sloth turned sleuth hired to investigate a missing person case. Although the plot appears harmless, the game's sexual themes and unique development has caused outrage amongst concerned parents. Adventures was created by Dubroff Interactive, a video game company which specializes in online gaming. The development of the game was primarily conducted by a team of MIT fraternity brothers interning for Dubroff. The college kids conceived of the idea for a video game to accelerate an adolescent's understanding of societal norms, similar to the pledging process at their fraternity. What Dubroff produced was an online video game very popular among teens. Many speculate, however, that the game is attractive because it is grounded in inappropriate sexuality. The game features scenes such as drug use, castration, and sex addiction. Several characters in the game work in the pornography industry, such as lead character Bunny and supporting character Jackie Freeborn. The game has other sexual themes as well. Several of the characters' voices are narrated by saxophone operators, and numerous scenes include spicy saxophone solos reminiscent of a 1970s-era pornography film. Despite the subject matter, the game has received wonderful ratings from gaming critics. However, not all are happy about Adventures. In the state of Froessel lies the quaint town of Sweetwater, a simple place of 8,000 known for its Amish-crafted cabinets and nationally recognized Apple Blossom Festival. Early last year, this charming township received an unwelcome reality check, as Sweetwater saw a steep rise in teen pregnancy. The cause for this trend is not completely understood. However, since the publication of recent studies illustrating the correlation between raucous teenage behavior and the sale of Adventures, townspeople of Sweetwater assert that video games are to blame. After the discovery of a pregnancy pact involving several 14-year-old girls, the locals of Sweetwater decided enough was enough. Parents lobbied Sweetwater's mayor, Farrah Kalin, to propose an ordinance to the local town council protecting the sanctity of their youth from the terrors of video games. Kalin pledged full support to her frustrated constituents, since she herself was made a grandmother in 2008 after her teenage daughter gave birth to trucker Kalin out of wedlock.
The result of this shared outrage was the creation of the Video Game Indecency Act, the VGIA. The law provides in pertinent part, it shall be unlawful for any person knowingly to sell to a minor any obscene gaming product within Sweetwater. Any violation of this ordinance is punishable per offense by a fine of up to $1,000. Obscene means the quality of any game which, 1, the adult community of Sweetwater would consider as a whole appeals to the prurient interest of juveniles. 2, the material or performance is patently offensive to prevailing standards in the adult community of Sweetwater as a whole with respect to what is suitable for juveniles. And 3, the material or performance, when considered as a whole, lacks any serious literary, artistic, political, or scientific value for juveniles. There was little opposition to the VGIA in Sweetwater. When signed, and the law still continues to receive broad support. After all, Sweetwater is a town with a strong conservative voting record, which Mayor Kalin boasts is rooted in its strong religious values. Her statement has merit, as the town of Sweetwater is almost completely comprised of members of Old Order Amish and newly reformed Mennonite religions. Most adults in town ostensibly consider the VGIA a proper standard by which to raise their children, and thus seem to have no desire to change the law. The procedural history is as follows. Dubroff Interactive filed suit seeking an injunction to prevent the enforcement of the VGIA. Dubroff challenged the statute on the grounds that the ordinance is unconstitutional as it is content-based and could not pass strict scrutiny. Additionally, Dubroff filed suit challenging the VGIA, claiming it unconstitutionally restricted the definition of obscenity to the local adult Sweetwater community. The district court For the District of Froessel found in favor of Sweetwater on both issues. The 13th Circuit Court of Appeals affirmed the District Court's decision on the first issue and reversed the District Court on the second issue, finding that a national standard should be applied when determining whether an obscenity exists. Both parties petitioned the Supreme Court of the United States for cert. The court granted cert on the following two issues. 1. Does the VGIA fail scrutiny under a constitutional analysis for depriving minors of their free speech without offering an adequate governmental interest or narrowly tailoring the remedy to meet that interest? And 2, is it permissible for a town ordinance to mandate that a jury sitting in an obscenity trial for material disseminated over the internet apply a local community standard under the Miller-Ginsburg framework? The petitioner will be arguing for the town of Sweetwater, while the respondent will be representing Dubroff Interactive. On behalf of the Moot Court Association, I would like to thank you all for attending, and I wish all the competitors good luck.
We're about to begin the final rounds. The judges are making their way down the hallway, so we'll be ready to begin in just a few minutes.
Please be seated.
The first case on the calendar this 26th day of the month of September is the town of Sweetwater against Dubroff Interactive.
In 26 years as a judge, I've never made an entrance like that I can recall. Counsel, you prepared to proceed?
Yes, sir.
Your Honor, petitioner requests 1 minute rebuttal time.
Granted.
Thank you. Good afternoon, Chief Justice, Your Honors. May it please the court, my name is Justin Ashenfelter. I represent petitioner Sweetwater on this appeal. Our requested relief is number 1 for this court to affirm the 13th Circuit's holding the VGIA survives scrutiny, constitutional analysis. Secondly, my co-counsel Brian Dolan will ask this court to reverse the 13th Circuit's holding that a national community standard be applied to internet obscenity cases and instead hold that a local community standard be applied instead. Sweetwater argues the following. The VGIA is a content-neutral restriction on speech and therefore should be accorded intermediate scrutiny review based on the secondary effects that the game Adventures has.
Why not strict scrutiny?
Well, intermediate scrutiny review, Your Honor, is more appropriate in this case in that the law does not focus on or seek to restrict the content of the video game. Moreover, it seeks to restrict the secondary effects that the game is having on on the town of Sweetwater, namely the uptick in teen pregnancy that we've seen.
But isn't there very, very little research or nothing almost in the record showing the causation between video games and the consequences or the so-called secondary effects? How can you say that was the point of the law?
Well, Your Honor, respectfully, we disagree. We argue that there is actually a strong causal connection between the release of adventures and this uptick in teen pregnancy based on several.
What's your basis for that?
5 studies conducted, Your Honor. The first that was conducted by a condom manufacturer who's targeting Sweetwater in its studies, holding that the pregnancy rate rose 2.5 times the national average since Adventure's inception in 2007, particularly in the town of Sweetwater. Also, the same manufacturer.
What was the showing of causation in that study? How did they show it?
Well, they showed that essentially by polling the teenagers in the town compared against the national community, that the birth records showed that there was a spike in teen pregnancy.
Does the record show anything about the methodology that was employed with that study?
With regard to the condom manufacturer, Your Honor?
Yes.
No, it does not. The record's silent as to that. However, we do have the statistics that 2.5 times the national rate, and that's actually exceedingly high considering Sweetwater is a small population of only 8,000 people compared to the rest of the national community. So the effects that this law is having on Sweetwater itself are actually, we argue that it is a direct result of this game. I mean,
Mr. Ashenelder, I think there's the same correlation, 2.5% higher exists when the Yankees win the World Series also.
Although that's strictly a matter of merit, of course.
I mean, the same thing occurred during that time period. You see what the court is driving at. We don't see the fact that there's a correlation as proof that the two things are related, even if stated to be related in the eyes of the people.
Well, Your Honor, there are additional studies conducted. I can't speak to the Yankees per se, but in the town of Sweetwater, since this game's inception, a number of things have happened. A study was conducted by Dr. Quine at Froessel State University, who found that by playing the game Adventures, the player actually increases his testosterone level while playing, which may result in active sexual activity.
And testosterone is related to pregnancy directly how?
Because the material has caused this increase in testosterone, as would pornography, and the end result is that people would, men in this case, would be more inclined to go act on their impulses, their sexual impulses, and we believe that Adventures is the cause of this.
Do we know anything from the record about the methodology that was used with respect to that study?
Well, they took a controlled group of 18-year-old men, allowed them to play this game, Your Honor, and then after that, they did I'm not a doctor, but I would imagine they were able to measure the testosterone level that rose since before they started playing the game.
Now, if we found that there was not evidence of causation, or at least nothing that was meaningful in that regard, do you lose?
Well, if the court finds that there is no substantial evidence to support intermediate or strict scrutiny review, then yes, we would lose. So therefore, we're arguing that the causal connection is actually substantial to meet the evidentiary burden that is required for intermediate review.
Let me then take you back to the jurisprudential underpinnings to that position.
Yes,
what is the authority upon which you rely to suggest the secondary effects theory?
Well, the secondary effects, this court, the Supreme Court, held in the city of Los Angeles versus Alameda Books. That was essentially a law in 2002.
It's a zoning case, isn't it?
It is a zoning case, Your Honor.
In fact, all your authority are zoning cases, aren't they?
Correct, Your Honor. Also in Erie versus Paps AM, which we argue that while that is a zoning case, and that had to do with geographic locations where you could put, say, a nudie theater or perhaps an adult bookstore, this is similar with regard to the internet in that we are restricting the time and the place where kids can buy this game.
How is that analogous at all to the kind of spatial uses that we're referring to when we're talking about municipal zoning? I fail to see how that analog can hold up.
Well, Your Honor, directly, there is no actual relation. We're asking you to compare cyberspace to geographic locations. And this is a case of first impression, Your Honor, with regard to the internet and obscenities regarding minors with the video games. The VGIA is a very narrow rule in that it only restricts minors from buying this game or obscene games like Adventures within the town of Sweetwater. Now, my co-counsel will speak later as to
how do you know it's located within the town of Sweetwater? I take it that the material was created outside of Sweetwater. The servers are located outside of Sweetwater. They could be downloaded outside the town of Sweetwater. As long as there's an internet connection, someone can get to things. How's that any different than using a telescope, looking across the city lines and seeing a nudie theater, the screens outside of the county limits? Why is that any different?
Well, because this video game, this material is being piped in, correct, Your Honor, to anyone who ostensibly has an internet connection can play this game. The internet can transcend jurisdictional boundaries, as we have seen here, and the effects are very real in the town of Sweetwater.
So, Mr. Anschfeld, let me ask you a question. Would the analogy be that you zone on the internet by having warnings, particular places called, X-rated land, places where you could cabin, if you will, material, so that there's warnings to everyone, this is what you're going into and this is where you're getting? Well, and putting it a different way, isn't there other ways of controlling access toward material that could have been tried first before an absolute ban?
Well, Your Honor, that type of technology does exist, and we find that Dubroff, the respondent, is in the better position to actually implement those types of safeguards, not the town of Sweetwater itself. They have the technological means, they have computer access. They're the ones distributing. They are the publishers of this video game, and they can do geolocation blocking. They can block IP addresses. They are in a better position to implement these types of safeguards than is the town of Sweetwater.
Was any of that tried here?
No, Your Honor, it was not.
Why not?
Well, there were other measures that were taken, and the VGIA was determined to be the last resort, essentially. And we also find that it would be the least restrictive measure of controlling this type of speech. For instance, Farrah Kalin, the town mayor, attempted to sit down and broker a deal with Leroy Arco, who would be the Dubroff CEO, and essentially go to the source where this type of information was coming from and say, listen, we're having a real problem, and we need you to adhere to the VGIA or some sort of age login verification, or perhaps maybe take other measures that would essentially prevent children from buying this game in Sweetwater.
Did that meeting occur after the adoption of the ordinance?
Before, Your Honor. That occurred before. And the VGIA was a result of the Leroy Arco and the company's non-adherence to this.
Counselor,
Yes,
I want to bring you back to something that concerns me that perhaps I misunderstood you to say before. Did I understand you correctly when we asked the question, what if we don't buy the secondary effects argument? Is it your position, are you conceding completely the strict scrutiny? You have no arguments there?
Well, we do. We will make a case for strict scrutiny. The 13th Circuit held that 13th
I'm
Circuit...
not asking you to make a case if you don't believe you have a good argument. I'm asking you, do you have a good argument?
We do have a good argument, Your Honor. And it is admitted that this court has never held up a law as being constitutional in this regard with Internet obscenity cases, that because the law has never been narrowly tailored, we hold that this law is narrowly tailored, being a case of first impression, that this law will actually survive strict scrutiny analysis, although it is relatively infrequent coming from this court.
Can you help me in understanding just how the Miller and Ginsburg precedents would work in tandem analytically for purposes of that inquiry?
Yes, Your Honor. Well, the Miller framework is a three-part framework, a three-pronged test, where essentially you are judging something that is obscene. It describes the three prongs that we would determine what would be obscene by judging by a local standard.
Sure.
In this case,
the court certainly knows what
yes.
Miller held. But how does it work hand in hand with Ginsburg?
Well, the verbiage itself of the VGIA and the Miller are closely aligned, almost verbatim, Your Honor, as to we've essentially adopted, the town of Sweetwater has adopted the Miller framework in testing obscenity, or determining obscenity. So verbiage and application in and of itself are essentially mirrored here in this case.
So you really think that there is none, not a serious artistic, literary, or scientific value at all?
None whatsoever, Your Honor. As a matter of fact, I know that the respondents will come up here and say that they'll cite to a study by Katie Cromaldi, a former doctor who had her license revoked, and they will say that essentially this game has some sort of teaching or learning value. And we argue that it does not. And they may say things like castration taken out of context.
Is there anything in the record of the courts below with respect to that testimony?
Well, they held that the game itself was
No, with respect to the Grimaldi testimony.
It's incredible, Your Honor, essentially. And the lower courts have not actually analyzed it, but we're putting it on the record, or we are citing to the record and saying that it is, in fact, the game is obscene, and that her studies should not be paid attention to.
Haven't courts and other government entities found that in the past about, maybe Jack Kerouac or literary, so-called literary things that were just written stream of consciousness without any thought, maybe while people were on LSD, and said this has absolutely no literary value, and then later critics have found otherwise.
Well, yes, Your Honor, but we would distinguish this from previous works. This medium of communication involving the internet, and particularly that it involves a video game. Essentially, video games are interactive, and that facet of this type of communication or game requires the young child to interact with the game. They are making the decisions.
It's not marketed for its educational or literary value, is it?
It most certainly is not, Your Honor. It's actually marketed, well, it was created by a bunch of frat boys who essentially wanted to, in our opinion, disrupt the pure nature of children, and particularly it has its effect of frustrating the child's healthy upbringing in this case.
Doesn't that have social value, and couldn't that be seen as scientific value?
No, Your Honor. We don't find that this game would have any value. I mean, particularly if they want to argue, if the respondent wants to argue that this game does have some sort of teaching value, and I'll draw your attention to level 6 of the game Adventures, where essentially the character, the protagonist, is forced to make a decision to either fight a woman or hop into bed with her. How this has any sort of impact or...
Mr. Eschfelder, I have to interrupt you 1 second. Just what's the legal standard that you're asking us to adopt here? That as a matter of law, this is without any socially redeeming value? Would that be what you're asking the court to take notice of?
That is what we're asking the court to take notice of on 2 counts, Your Honor.
So before we go on from that, what do you make of your Exhibit A of the record, where there is a review that was made of this game by Mr. Bobby Hagstrom, who concludes, crude, funny, disgusting, thought-provoking, perhaps inappropriate for certain eyes. That's why we love it. Game is one of the freshest ideas in years. What it lacks, it makes for healthy doses of reality. And parents may want to keep in mind they could be shutting their children off for more than just a game. I read this review as suggesting by some person, is this guy also patently incredible, to be completely dismissed, that there is a suggestion within the record of your very case that says this may have important value, reality value, that will help people to cope with life situations. We have to completely discredit that?
Yes, Your Honor, and we believe that Bobby Hagstrom, whoever
Why?
he is...
He calls it an idea. He uses the word idea to describe it.
Your Honor, I see my time is up.
You may answer the question.
Okay. He does pose an idea, but he would be a member of...
He refers to it as an idea.
Pardon me, Your Honor?
He refers to it as an idea.
He does refer to it as an idea. We claim that this law, or this game in and of itself, is not a great idea. It's a bad idea for our children to play. And essentially that wherever Computer World magazine is published, whoever they are, that their review should be taken with a grain of salt. Thank you very much.
All right, thank you. We'll have you back on rebuttal.
Good afternoon, Chief Justice, Your Honors. May it please the Court, my name is Brian Dolan, and I also represent the petitioner, Town of Sweetwater, on this appeal. Petitioner asked this Court to reverse the decision of the Court of Appeals on the 13th Circuit and find that STO 1776, which I will hereafter refer to as the statute, is constitutional in its application of a local community standard. Your Honors, this case today is about a state's right to protect children, and petitioner contends that the statute at issue constitutionally upholds that right for 3 reasons. First, this statute is a lawful regulation because this court has consistently ruled that local community standards are preferable for judging obscenity.
Except in all of the other video game cases where states have tried to ban the sale of video games because they're too violent and that's to protect the children, haven't they all been struck down?
That is true, Your Honor. Now, none of those cases were decided at the Supreme Court level, however, and we would also distinguish that today in dealing with obscenity, we are looking through the Miller framework, where this is an appeal to the prurient interest of sex rather than that of violence.
What is obscenity? An appeal to the prurient interest?
Yes, Your Honor. Obscenity is...
Then what is prurient interest?
Prurient interest is that appeal of a sexual nature. I would define from Random House Dictionary, 2010 edition, suggesting that prurient is having lascivious or lustful thoughts. Your Honors, this court has consistently ruled for nearly 40 years that community standards are preferable for juries to apply in judging obscenity as established in the test under Miller v. California. Now, a mere 5 years prior, this court said in Ginsburg v. New York that states may regulate dissemination of objectionable material as to minors. Indeed,
if you looked at a town of about 20 people and you polled all 20 of them and you got to 11, and the 11 said basic American television with all those women parading around in those kinds of clothes is just so darn arousing for our kids, the 4 that we have, that we're going to ban television from our community. Could you do that?
Your Honors, petitioner would concede that a small town may be able to come to such a decision in the example you've cited. However, here, when we're looking at the internet, we believe that this statute could constitutionally apply such a standard as what you're applying because it is both a permitted exercise of the 10th Amendment state power to regulate at the local level and uphold its own moral fabric.
Do you think there could be a little bubble around a town where everything that happens in the rest of the world they could prevent from happening in their town? I mean, what I'm driving at, Mr. Dolan, is how do you turn off the internet? Local standards, what kind of country would we be if every community could define for itself how the internet would apply within its community? Is that a feasible way to regulate a new medium that essentially is without physical boundary, that is worldwide by its very definition, World Wide Web, that creates material that's user-based content? All those things are different than anything we've ever faced before as a regulatory matter. Does it make sense to you, Mr. Dolan, that every small town in this country on anything that might be mildly controversial is in a position to ban it from their location?
It does make sense, Your Honor, although petitioner does concede that in its application there are certain problems that may arise. I would remind this court of what you all said in Sable versus FCC, that it is the company that ultimately bears the burden of complying with the prohibition on
Is that really a strong precedent, however, for your argument? Isn't Sable distinguishable at the very least because it dealt with FCC regulations and the highly regulated regime that the federal government has has exclusive jurisdiction over?
Yes, Your Honor. There may be certain factual distinctions between Sable and the case in Barr today, but I would also suggest, given Justice Madisar's question earlier, that on a television, broadcast television also being a federally regulated medium, that such narrowly tailored options as the V-chip exist for parents in that instance, or simply people who may choose to not watch certain programs on television, would be able to keep that from coming into the home. Now, we know from page 4 of the record here that many of the aspects that the town of Sweetwater, the parents there tried to keep their children from being able to access this game failed.
If they left Sweetwater, the kids, got into the car, drove out the county line, crossed into the rest of the county, and then downloaded it, would that violate the local regulation?
Well, petitioner concedes, Your Honor, that there are certainly ways around this law should a child choose to exploit it. In no way does this law today suggest that a parent is prohibited from purchasing this game for their child.
If it was purchased by someone else and then given to the kid in the town through file sharing where they paid nothing for it, could you ban it that way?
Well, Your Honor, the game itself would still have to be found obscene under this trial as to the framework of minors.
Definitely, it's the same game. It's just that it wasn't purchased, it was shared.
I would still argue, Your Honor, in this case that the game itself would have to be found obscene. And if it was then found obscene, I would say that this only refers to the commercial sale of the game. If it was obtained through otherwise illegal methods, perhaps that would run afoul of illegal downloading laws, but I don't think it would specifically violate this statute.
Can we get back to why this is obscene? Why is it obscene?
Your Honors, petitioner asserts today that this game is obscene as to minors due to its glamorization of the sexual behavior, pedophilia, castration. Now, the respondent today
There's no castration on it at all, is there? There are no pictures of castration or of any other sexual activity.
Well, actually, I must respectfully disagree with Your Honor. The record does state that this game contains castration, pedophilia, other pictures.
The issues are raised, is that correct? However, there aren't graphic pictures. And is it your contention that just having a discussion about these issues is obscenity?
It is our contention, Your Honor, that this glamorizes such behavior and makes it a message is presented in the children that it is okay to engage in such behavior. And we're arguing today that parents and states have a right to object to this sort of thing under 10th Amendment regulatory framework and saying that they will not allow such images and depictions into their own communities.
A local politician advocated for castration as a penalty for rape. Would that also violate your law?
Your Honors, I would disagree that that would violate the law.
I'm just asking.
I would say no, because first off, we must remember that this isn't a framework in its suitability as to minors. Secondly, this law is narrowly tailored in looking at video games distributed online.
If there was a game called Lolita, the game, and you had a professor who took up with a young woman under the age of consent, kept all the text from the novel Lolita, did that violate your statute, your ordinance?
I would submit, Your Honor, that a trial would still have to take place. A jury sitting in Sweetwater would still have to make that local determination.
Well, if you were the prosecutor, would you recommend that they indict the company or seek to prohibit that sale of the Lolita, the game, within the jurisdiction?
Your Honor, I think if it rose to the level of content that we find in Adventures in Chabowski Land, I might be willing to make that argument.
Of course, no one would ever suppose that a real-life professor would do such a thing.
No implication from here, Your Honor. Your Honors, if I could just talk momentarily about the national standard itself. There's an idea out there that it might somehow give a veto power to the least tolerant community in this nation. This court told us in Miller that the mere fact that juries may reach different conclusions as to the same material does not render a statute unconstitutional. Furthermore, this court also told us in Hamling v. U.S. that just because distributors of allegedly obscene materials may be subjected to varying community standards in various judicial districts into which they transmit, this does not render a statute unconstitutional.
But what about due process? I mean, how does anyone have any notice of what's okay and what's not okay if we live in a country where something's been found to be acceptable and not obscene on this side of a line? You step over the line and all of a sudden you're in trouble. How does anybody know how to behave?
Well, petitioner submits, Your Honor, simply from a policy standpoint, even though we're dealing with internet dissemination here, it's still incumbent upon businesses to be aware of what those local laws may be.
But isn't that the point? At the root of law is the sense that we can provide rules that have reliability, rules that give notice, rules upon which people can form and shape their future conduct. How does the system that you would have us adopt yield anything other than a system of ad hocery based upon geographic location?
Your Honor, petitioner submits today that because this law would pass a strict scrutiny framework and that is narrowly tailored, the law as it stands now, the text, would provide that adequate notice. I would say to the respondent today, if they wish to continue selling their game in the community, that they should take a hard look at this law.
What about the chilling effect that would necessarily have on speech? Even if somehow we said it was fair to have, speech not allowed here and not allowed and allowed there, what about the chilling effect on the speech of other people? and the way that that would inhibit the First Amendment protection.
Petitioner disagrees today that there would be a chilling effect with application of this law, Your Honor, because it is specifically tailored to that of minors. There's no constitutional, it's not where I wanted to go with that. Your Honors, if the respondent is allowed to continually distribute Chabowski to minors in Sweetwater, there's an implication here that online video game makers have a constitutional right to post sexually explicit material on the internet, readily available for looking at by any minors, regardless of what the parental concerns may be. We submit today that because this law is narrowly tailored, there would not have to be any particular changes that would be made to the game that would prevent, for example, 2 different versions of the game happening. There's no implication on the record today that adults can't get a hold of this game. And we would argue finally that the imposition of a national standard by the court would ignore the 10th Amendment regulatory interest for states to seek redress for their very local concerns for their minors through legislation. This is a federalism problem that I'm arguing, Your Honors. And this court told us again in Miller that standards of obscenity are predominantly regulated by the states and therefore dependent on local concerns. Going back again to the idea that Chabowski would sort of give Sweetwater a protected financial gain at the expense of minors, it's petitioner's contention today that the local community standards in this statute are a 10th Amendment protect guard against such exploitation of minors, Your Honor. Now, in direct contrast to any assertion from the respondent today that local standards can't be ascertained on the web, I would submit to the court that...
What do you mean by ascertained in that context?
Well, I would say, Your Honor, that in fact technology does exist, even down to the IP level that would allow respondents to limit this game. The problem, Your Honor, was that the age verification the respondent might suggest would be a more narrowly tailored option is unworkable. I don't know if Your Honors are familiar with age verification, but the way it works on the internet, if I were, for example, a 9-year-old boy in Dubroff and I wanted to access a pornography website on the internet, that I could simply add 10 years by typing it into my age on the computer, and then I would have access to the site. It's these very kinds of limitations and the technological savviness of children.
Right. It's not foolproof. Why should we? I mean, generally we try to leave that area for parents and caregivers to enforce. Obviously, the state, the government, the court can't be in every child's bedroom or in the kitchen or wherever the computer happens to be, and with laptops it could be outside or on the school bus. But it's not foolproof. Why do we call it narrowly tailored with video games when we can't do that with anything else? Anything else on the web, we don't limit speech like that.
Petitioner agrees, Your Honor, that the government in this instance shouldn't be coming into the home and that this all starts with the parents. The problem, however, is that the technological advances in our place, the mobility of laptops, this makes it extremely difficult for parents to be there and monitor the online activities of their children.
Mr. Dolan, if I can, I'd like you to help me to know where our decision in this case, what guidance it's going to be giving to communities around the country. What are the limiting principles, if any? So I'm going to give you a hypo and tell me how you come out on this, if it be constitutional. A local jurisdiction says, you know, there are all sorts of terrible pictures being posted by young people around the world on their websites that they hook them into this thing called Facebook. And they walk around with very little clothing. They write crazy things about advocating, castrating the teacher who gave a bad grade, dating children who are younger than they are, under the age of majority. And we think that's a terrible set of values. We therefore declare in our local community that participation in Facebook is a violation, and access to Facebook is a violation of our local ordinance because it appeals to prurient instincts of young people in our community, and it will interest them in the other sex. They're going to become more pregnant than they would have been without these things. Would that one be constitutional too?
Your Honors, I see that my time has expired.
You may answer.
Okay. What I would say, Your Honors, that is distinguishable from the statute at bar today.
So what are the key factors?
Well, we're looking at the commercial distribution of this game today, Your Honor, and we're looking to its effect of obscenity on minors through a trial process. The first two prongs of Miller, which mandate the local standard, we submit to the court. A trial still has to happen in any town for something like this to be declared as obscene. Thank you, Your Honor.
Thank you, Joe.
Good afternoon, Chief Justice, Your Honors. May it please the Court, my name is Gaurav Dave, and I'm representing the respondent, Dubroff Interactive, on the first issue on appeal. My co-counsel, Gretchen Jenkins, will represent the second issue on appeal and argue that it is impermissible for local ordinance to order a jury sitting in an obscenity trial for materials disseminated over the Internet to apply a local community standard. On the first issue on appeal, Your Honors, the respondents will argue that the VGIA is a content-based regulation and thereby subject to a strict scrutiny analysis. Furthermore, we will show that there is no compelling government interest to enact the VGIA, and that furthermore, that the VGIA is not narrowly tailored to further this government interest because it is not the least restrictive alternative.
Well, what is your response to their argument that it's not a content-based ordinance or statute, that it's in fact focused on the secondary effects of conduct, and that they don't really care about the content, they care about what's happening to young people in their town, and really that's what's motivating this statute, and so therefore we should impose intermediate scrutiny.
Justice Abraham, we respectfully disagree with that contention. This court clarified the definition of a content-based regulation in the case of the United States v. Playboy Entertainment, where it stated that a regulation is content-based when the speech in question is defined by its content. In the case at bar, the speech in question is the video game Adventures in Chabowski Land.
But doesn't the very text of the ordinance demonstrate on its face that the motivating, the animating concern of the town was what this particular game would do to minors? It was not an effort to ban the content outright. Doesn't a look by this court at the text itself make the point that the focus, the concern of the municipality was more narrow than general content?
Chief Justice, we agree and disagree with your statements. We agree that the second prong, that the regulation does state that they want to protect minors from harmful material. However, we disagree because the second prong, which the respondent claimed is in accordance with the Miller-Ginsburg framework, states that it defines material in a patently offensive way. It does not speak to the harmful secondary effects per se. Furthermore, Your Honor, the VGIA seeks to restrict Adventures in Chabowski Land not because it's a video game en masse, but because it's a video game that contains the allegedly harmful material contained therein.
Do you agree that a concern for the welfare of minors is itself, irrespective of what your position may be concerning what Sweetwater did in this case, a legitimate concern for purposes of legislating?
Your Honor, we do agree that protecting minors from obscene speech is a compelling government interest, as this court stated in Miller v. Ginsburg. In Miller v. California. However, in Turner versus the FCC, this court stated that the alleged harms have to be real, not merely conjectural, and that the regulation will, in fact, alleviate these harms in a material and direct way. Furthermore, Your Honor, in the case of Reno versus the ACLU, this court stated that just because a regulation protects children from sexually expressive material, it does not foreclose inquiry into its validity. The respondents interpret this holding as that the burden remains on the town of Sweetwater to show substantial supporting evidence. The respondents contain that substantial supporting evidence has not been submitted. In the case of Ashcroft v. Yes, Your Honor.
Is it your contention that this material is not obscene on its face?
Absolutely, Your Honor.
And why is that?
There are two reasons for that, Your Honor. The first reason is that the VGIA claims to be in accordance with the Miller-Ginsburg framework. There are many factual discrepancies between Miller versus California and the case at bar. The first being that this court held in Miller that state must uphold restrictions on obscenity when there are unwilling participants who are unable to...
But I'm asking a different question.
Yes,
Your adversary says, we got to the strict scrutiny possibility, that this material glamorizes things like castration, that it's marketed solely commercially, it has no social value, no literary value, nothing, and even its producers don't claim to the contrary. So why isn't it obscene?
Your Honors, we disagree with that contention. When the petitioners brought up the claim of castration and pedophilia, it has to be taken in context, just as Miller-Ginsburg framework
What's the context?
stipulates.
The context is it's one of the options that's given to win the game.
Yes, Your Honor, but the option is given when a character who's essentially cast as a notorious villain in the video game is a pedophile, and the lead characters are given an option to either castrate him or confront him in a different manner. The respondents believe that this points to the choice options that are given to children, as in the case of right versus wrong. We are actually punishing.
No. Are you claiming that this was intended to be and is of educational value when neither the people who invented it nor the company that sells it has ever remotely made that claim until this lawsuit?
Sure, Your Honor. Your Honor, let the record reflect that the intention of the manufacturer has never been brought into account when frames of obscenity are brought in front of the court. It is, however, brought into court what actually redeeming values are in the game. For instance, Your Honors, there are discussions about pacifism in the game. There are discussions about Jewish orthodoxy and National Socialism in the game.
So do I understand your position now, and I'm sensing this from your response a moment ago to Justice Redkoff's question, that there may indeed be not only or possibly some educational value, but some kind of moral message indeed of right and wrong? Is that where you were going a moment ago?
Your Honor, the game certainly contains a choice-based framework where there are often options between right and wrong, and there sometimes are, as true life shows, there are sometimes options between wrong and a lesser evil.
Well, for there to be some kind of lesson as to that choice, there would have to be some suggestion, I presume, that the one course is preferable to the other. Is there anything in the record showing that this game suggests that such a choice offers one better alternative or one, quote, moral alternative over another?
Chief Justice, the record does not reflect that one option, either right or wrong, is shown as preferential. However, that is not what the Miller-Ginsburg framework requires, that a choice of right or wrong.
Well, I just wondered where it was coming from. I may have misunderstood your argument. I just thought that seemed to be where you were going.
Thank you, Your Honor.
What is the best case for your position? Even assuming it's a case of first impression, what's the best case in support of your position?
I'm sorry, Your Honor.
The best case in support of your position.
Sure, Your Honor. We believe there are many cases, but one important case would be, one important case would be the case of Ashcroft versus the Free Speech Coalition, where the government contended that a virtual child pornography whets the appetites of pedophiles and encourages them to engage in illegal behavior. However, this court refuted the government's statement by stating that the mere tendency of speech to encourage acts is not a sufficient reason for banning it. In the case at bar, Your Honor, the petitioners have submitted only 5 studies that show perhaps greater than a mere coincidence that there's a rise in teenage sexual promiscuity due to the playing of video games.
Can I interrupt you there for just 1 second?
Absolutely, Your Honor.
Let's suppose for just 1 second there were a slew of studies, all of which showed that this game had a direct relationship to an increase in teen pregnancy. Could the town of Sweetwater, under those set of circumstances, regulate the sale of this game within its borders?
Your Honors, that would be a yes and a no. I'll answer first yes. It would be yes, because if the town of Sweetwater...
I presume you prefer one over the other, the yes over the no.
Yeah, absolutely, Your Honor.
So, and the no part I kind of get in advance that you're going to get to. So can you help us out with the yes? Under what circumstances would the evidence be sufficient for them to regulate?
Sure, Your Honor. In the case of the City of LA versus Alameda Books, this court stated that a state must draw reasonable inferences from substantial supporting evidence on the record. And as is also stated, a substantial supporting evidence standard is a but-for causation. We do not believe that this standard has been satisfied, Your Honor. The respondents have also submitted many reports from our team of psychologists that state to the contrary. The petitioners claim that pregnancy pacts were formed in enactment, and which led to the enactment of the VGIA. However, our psychologists ultimately concluded that these girls that formed a pregnancy pact were
Is there a single reported study, psychological study, anywhere in the history of the world that establishes but-for causation? Can that really be the test?
Your Honor's respondents cannot answer that question, whether there is a study in the history of the world. However,
does the legislature
Mr. Wright, could anyone ever regulate on anything with a but-for standard?
Your Honor, in Ashcroft v. ACLU, the government submitted over 1,000 reports to show that, yes, this will be substantial supporting evidence. However, we do not believe that 5 studies would contend and show a but-for causation, Your Honor.
How about if there were direct testimony from the young women of the city, and they were testifying on the stand, I never would have thought of getting pregnant, but watching this game inspired me. That was, in fact, the cause of my pregnancy. If that evidence were in the record, would that be sufficient?
Perhaps if there were a significant number of females that attributed to that statement. However, on the record, there were only 5 females that stated as such.
So would it be an appropriate result for us to remand this case for factual findings on the question of whether the evidence is sufficient in this case to demonstrate that there is a relationship between pregnancy and the playing of this game?
Your Honor, while the court is free to remand it on those grounds, the respondents contend that the VGIA will not even pass a strict scrutiny analysis due to the fact that it's not narrowly tailored.
Okay, but again, you need to help me out on this one.
Sure, Your Honor.
If, in fact, there were secondary effects that led to an increase of teen pregnancy caused from watching this game, would you agree that the standard then was intermediate scrutiny?
If these harmful secondary effects were proved, Your Honor, then yes, we would. However, we feel that that has not been presented so far.
Okay, so let's walk it through.
Sure.
It's going to be intermediate scrutiny if they can make the case that the secondary effects exist. You agree?
Yes, Your Honor.
Okay, so let's just assume for a second that they've made that case. Do they win?
They do not win, Your Honor, due to the fact that this game will still not qualify as obscene as per the VGIA and the Miller-Ginsburg framework, Your Honor. Furthermore, Your Honor, we argue that there are lesser restrictive alternatives than the VGIA. One example being that the town of Sweetwater could enact laws that increase parental awareness of the ESRA rating stickers that go on these boxes of video games. Furthermore,
but petitioners contend that they tried at least one alternative means and it didn't go anywhere. Would you require them to try every possible alternative?
Your Honor, the word of the law and this court is that it has to be the least restrictive alternative, and therefore the respondents construe this as even if there's one more lesser restrictive alternative, it has the VGIA would not pass constitutional muster. The respondents have placed several lesser restrictive alternatives on the record, another being parental safeguards, such as the one that were employed in the case of Ashcroft v. ACLU, where coded filtering systems from parents were deemed to be a lesser restrictive alternative on obscenity statutes. Furthermore, Your Honor, in 250 years of American jurisprudence, a statute has never passed a strict scrutiny analysis, and the respondents contend that due to the fact that the VGIA is not narrowly tailored and there is no compelling government interest and that there are lesser restrictive alternatives, it certainly does not deserve merit to be the first one. Thank you.
We kind of pride ourselves on being first sometimes, but thank you.
Thank you very much.
Good afternoon, Chief Justice, Your Honors. May it please the Court, my name is Gretchen Jenkins, and as co-counsel Mr. DeVay mentioned, we do represent the respondent, Dubroff Interactive, in today's appeal. Your Honors, we respectfully request that you affirm the 13th Circuit Court's opinion that the national community standard is the correct standard to apply when an obscenity case is before a jury in which the material was disseminated over the internet, for the following three reasons. Your Honors, the Miller test is unworkable in light of today's technological changes.
Does adoption of a national standard mean that we would have to overrule Miller?
Your Honor, respondent does not assert that it would be overruling Miller per se, but tweaking the standard by which the first two prongs are analyzed on. As it stands now, Your Honor knows that
what does a jurisprudential tweak look like?
Your Honor, we do not believe that Miller needs to be overturned in order to make this test work. And in fact, Justice O'Connor in Ashcroft versus American Civil Liberties Union did provide insight in saying that this court is not prevented from precedent from modifying the Miller test. So we are not advocating today that you overrule the Miller test, just apply a national standard.
But you do want to modify Miller.
Yes, Your Honor, we do. We feel that it is no longer workable in light of today's technological changes.
And in what way do you want to modify it?
Your Honor, we would assert that the national standard should apply to the first two prongs, as the national standard is applied to the third prong today.
Why isn't that overruling Miller?
Your Honor, because we believe that the framework of Miller is still good, that the three prongs, whether it applies to appeals to a prurient interest, whether it depicts sexual conduct or excretory functions in a patently offensive way, and whether it lacks serious literary, artistic, political, or scientific value, are still good steps in Miller. However, it's the application of Miller that we're asking you to look at today.
What's so different about the technology?
Your Honor, with the advent of the World Wide Web, things have changed dramatically. This court has had jurisprudence on many cases before. This court has seen Paris Adult Theater versus Slayton and Jacob Ellis versus Ohio.
Well, I mean, isn't the problem here that you're dealing with is how to keep something that is a national or international means of communication out of a particular vicinity, a particular locale. That was true when Miller was decided because of radio and television. Yes, this is a more difficult technological challenge, but in principle, what's the difference?
Your Honor, we submit that the internet is very different from the television or the telephone at that time. With the advent of the internet, it is impossible for the manufacturer or the person disseminating the information to know where that is going at any given time. As Justice Abraham alluded to, there is a considerable due process argument there that the manufacturer is never completely on notice as to where that product is.
But wasn't that true before the internet? That's true with newspapers, magazines, books, as well as television and radio. You know, things, people could have access to things anywhere in the country at any time. It's no different. I mean, it's really not, it's just a difference of degree.
Your Honor, we contend that it is different. In fact, with the newspaper, things like that, arguably the manufacturer knows where that newspaper is being sent to and how many of those are being sent there. Here with the internet, there's no control in knowing how many people will log into that page and pull that up.
Well, if I'm reading the newspaper on the train and I leave it in my seat and somebody else gets on in Pennsylvania and picks up my newspaper, it's not really, there's no way that the newspaper publisher could predict that.
Your Honor, we do agree with that. However, our concern more so is with Dubroff's expectation, or the expectations of Dubroff here. It's not as much with the secondary effects of you leaving a newspaper on a seat so much as it is a manufacturer sending a newspaper to that jurisdiction. And here with the advent of the internet, the local community standard that this court has had so much jurisprudence on is no longer feasible. If you will, Your Honors, with the .com era, the local bubble burst.
Ms. Jenkins,
Yes, Your
a
Honor.
question about how a national standard would work. It's been said that the United States now is made up of several different nations. There's a red state nation and a blue state nation. There are the religious and the non-religious. There are those who are liberal and progressive and those that are conservative and Tea Party. When we try to establish a national standard, isn't that a quest ultimately for forcing the will of some on others? And the advantage, as I understand it, of our test in Miller was to allow local communities that may clearly have some views that are out of the mainstream or out of the majority to be able to regulate locally those things which may be perfectly appropriate someplace else. What's wrong with that philosophically?
Your Honor, what's wrong with that is that we can't reasonably expect a manufacturer like Dubroff to tailor to, as it's now said in the last census, over 35,000 different communities across the nation.
With due respect, when Al Goldstein published Screw magazine, my guess was he was intending to sell it wherever it could be sold, but we and others at that time believed that that wasn't an appropriate standard for some community where the things that were being published were so much appealing to prurient interests that they would in fact violate the rights of the people of that location. Don't we owe some respect to the location, to the locality, to the local mores that are not outside of some mainstream, but nonetheless maybe out of favor with the majority?
Your Honor, we do agree that some respect is owed to them. However, I would point you to the decision of this court in American Civil Liberty Union, in which Justice Breyer said that we should look at the nation's adult community taken as a whole, not the individual communities.
Well, that was a
like
concurring
Sweetenham.
opinion, wasn't it?
That was a concurring opinion,
He
Your
was
Honor.
not speaking for the majority.
That is correct, Your Honor, but we believe that it's not merely dicta, and we believe that Justice O'Connor as well as Justice Breyer's concurring opinion.
Well, that makes 2 out of 9.
Yes, Your Honor, we believe that that does hold water, and we also believe that Justice O'Connor's opinion that perhaps the most important thing here is that Miller does not prevent this court from, precedent doesn't prevent this court from modifying Miller in order to meet today's contemporary standards.
Ms. Jenkins, in First Amendment theory, we are often worried about protecting minority speech against majority imposition. This is an unpopular local opinion that might be exhibited here in Sweetwater. But it's a town that has a clear picture of who it is, and what its values are. Most of the citizens within that local jurisdiction, most of the adult citizens, are favorably disposed toward this legislation. And in fact, they have a local problem that they're trying to deal with of teen pregnancy. Should we really be imposing a set of standards upon the Sweetwaters of our country that will force them to embrace the values of a world that they think has gone haywire? Is that really the right role for this court to move the standard in a way that prohibits local jurisdictions from trying the best they can to enforce their very small minority community against an oppressive will of the majority?
Your Honor, we believe that a national standard is more appropriate overall, and dealing with Sweetwater's small local community, it is respondent's position that Sweetwater may not be as conservative as it might claim to be. Obviously, there is great use in laptops in the town of Sweetwater as well as the internet. So perhaps this conservative local community standard isn't quite as local or as different from a national standard as one might think.
Suppose we're in Las Vegas and we know that everything that happens in Las Vegas stays in Las Vegas. Well, and we know that it's everything depends on its finances of what it does in Las Vegas. Do we just cut Las Vegas out of the national standard?
No.
Or how does a jury apply that?
No, Your Honor, we believe the national standard is that what a reasonable person in the nation would agree. And towns like Sweetwater and cities like Las Vegas, in the end, would ultimately balance each other out. Furthermore, the national standard isn't something that is a mystical creation. I mean, it already applies.
What is the balance? How do you balance Las Vegas and this community that we have before us?
Your Honor, it is the national standard, what a reasonable person would believe.
But doesn't that make reasonable persons virtually fungible?
Well, Your Honor, that is the standard by which courts use today for tort cases.
But respectfully, I'm not sure you answered my colleague Justice Madisar's question, which I understood really to be, isn't the value of self-governance and self-determination on the part of local communities, which have identified, as it may be, Sweetwater has a problem of a high pregnancy rate among its youth. Shouldn't there be a right on the part of such communities to determine how best to confront a problem of this kind? And if it perceives a national standard as being inimical to its own interests, shouldn't it have that right to determine how it goes forward?
Your Honor, respondent does believe that a local community does have a right to look out for the welfare of their child, that is a compelling state interest. However, when looking at the situation as a whole, the local standard is unworkable. The national standard is the only optional, the only feasible choice with the advent of technology.
How do you determine this national standard? It sounds hopelessly vague to me.
Your Honor, the national standard is already being applied in the third prong of Miller. We would simply ask that that same national standard be applied to the first two prongs. And then just last year in United States versus Kilburn out of the Ninth Circuit, they did just that. Petitioner has asserted that United States versus Little out of the 11th Circuit this year is different in that they did decide a local standard should be applied with the internet. But the facts of that case are distinguishable from the case today in that someone went online, ordered a pornographic DVD, and the DVD was shipped to them. Again, that was a physical manifestation, which is something this court has dealt with before.
So if I were, hard to imagine this, but if I were just a simple trial judge, and I were instructing a jury as to how to make this determination, what would I be telling?
Your Honor, you would tell them the same thing you would tell a jury if they were sitting in a tort case. What a reasonable person would expect to appeal to the prurient interest, to be patently offensive in a sexual conduct or excretory functions.
But Counselor, isn't that exactly the problem? A reasonable person in Sweetwater, people in Sweetwater would have a completely different idea of what that might be from a reasonable person in New York.
Again, Your Honor, I assert that the reasonable person in Sweetwater is not all that different from the reasonable person in the rest of the country, and that we did discuss they do have the use of laptops and internet. This does not sound like
You've never been to Sweetwater where you wouldn't say that.
Yes, Your Honor, but this does not sound typical for an Amish community. Your Honor, we also think that it's impractical and it unfairly burdens manufacturers like Dubroff to try and specify over 35,000 different programs to apply to different communities like that. Not only is it almost impossible, but the monetary means of that would have a chilling effect on speech. Due to the expansive reach of their product, a national community standard is appropriate.
Is there any room left any longer for local regulation of print or media content of any kind? If we take your argument seriously, Ms. Jenkins, are we really writing out entirely from all media? You know, why the difference between the internet and any other type of presented material? You'd like us to draw that line to offer internet, we're going to go national, but would that also be true on everything else?
Your Honor, the case before the court today deals strictly with the internet, and that's what we are here to advocate. If Your Honors did want to lay down a clear-cut law for other forms of medium, that would be entirely up to the court. Today we are mostly concerned with the internet.
What do you make of the relationship between the First Amendment and the 10th Amendment? I mean, in your view, Ms. Jenkins, is there anything left any longer for local governance, for local carve-outs, for local idiosyncrasy when it comes to protecting the citizens of a location? And for example, could they criminalize activity in Sweetwater more onerously because it's just so offensive to them than down the street? Let's say they think theft of property from a child is so significantly worse than theft of property from an adult, they enhance penalties. That would be a little out of line with what other parts of the country are doing. Could they do that?
Your Honor, we do believe that there's still 10th Amendment power and that the town of Sweetwater does have the right to regulate some things. However, with Dubroff here, we have an interstate commerce issue. We have an issue that Dubroff has to be on fair notice of what they're subjected to in each individual community. And so for that reason, a national standard is much more appropriate.
Well, we can feel that way about like guns in a school zone or things like that. I mean, why is this different?
Your Honor, I see my time is up. May I briefly conclude? Your Honor, again, the medium here is the difference. The medium is the internet. It's not a physical manifestation like this court's prior jurisprudence has dealt with. And for that reason, we do ask you to affirm the 13th Circuit. Thank you, Your Honor.
Thank you. Mr. Ashfield, a rebuttal.
Your Honors, petitioner wishes to waive our 1 minute of rebuttal time, and we'll rest. Thank you.
Thank you.
All right. Thank you. Counsel, we appreciate very much your arguments with respect to the two basic issues presented in this matter. The court will, at this time, retire and deliberate the matter, and I do anticipate that before the end of the afternoon we'll return with word on what we've decided.
All rise.
Name tags in front of each competitor so we can refer to them correctly.
All rise.
Please be seated. This is, I believe, the fifth occasion, the fifth year that I have been a part of a panel judging the Froessel competition. I've enjoyed it every year immensely. And every year it has been difficult while the judges deliberated to reach the decision we had to reach. Probably it would have been an easier decision to reach had we been deciding the merits rather than to have to try to come to grips with who had done the most effective job as an oralist. But that was our charge. That's what the competition is, at least in part, about, and what our rules are about. And so after some considerable discussion, and not to mention the mathematics the dean went through as we tried to tabulate our winner. We reached the conclusion, and I realize it's going to sound as if this is not a terribly decisive court, but we reached the conclusion that we have a tie for best oralist between Ms. Jenkins and Mr. Dolan. So we congratulate And this was not a split the baby decision. This was a genuine determination made by all the judges after considerable discussion and our good faith efforts to weigh the approaches and arguments of all four of you having done an extraordinarily effective job.
Your honors aren't going to make us argue again, are you?
You weren't that good, Mr. Dolan.
We were thinking of giving you each a copy of Chabowski and having you play each other.
It's also a part of this competition and customary, if not useful, and we hope that it's useful as well, for the members of the panel to provide comments to each of you, or some of you, as to techniques that you employed, points that you made, points that you may have missed. And so with that in mind, I'm going to call upon my colleagues to address some comments to you. And let me first call upon my colleague, Judge Smith, the other Judge Smith, who also is a veteran of this competition and has judged this competition before.
Thank you very much. You'll notice that when we came in the second time, that we walked much slower than the first time, and I certainly appreciate that. I have a left knee replacement that has slowed me up considerably, and I asked the dean specifically to slow down the second time, and he complied. I thought that all four of you were excellent. I was an appellate judge for approximately 19 years in the first department here in Manhattan, then in the Court of Appeals in Albany. I think you can all be very proud of what you did. I would only say continue what you are doing, and you will have certainly very successful careers. I've also taught at Fordham Law School since 1981, or some years before some of you were born, and in arguing with students who get smarter every year, I think, again, you showed that you are right there at the top. So congratulations to each and every one of you.
Thank you, Judge Smith. Judge Rakoff is truly one of the stars of the federal judiciary. It's always a pleasure to see him, and I think this is the third time out of the 5 I've judged that I've had the pleasure of being with Judge Rakoff. And veteran that he is, I turn the microphone over to him to present some comments to all.
Well, that was very, very kind, Judge Smith. It's been my great pleasure. I've also judged this 5 years, but not the same years as Judge Smith, but the last 3 years we've been together, and it's been a remarkable thing. I think he and I are always very grateful, as is the other Judge Smith, when the law professors let us get a word in edgewise. Each year I come back and feel privileged to come back to this competition because it is at such a high level. So I take the very great liberty of offering a few suggestions, but with the caveat that you all were terrific, and these are quibbles and small points. I thought that the first speaker made a tactical error in conceding when I put the question to you about if you can't show the secondary effects were caused, do you lose? And you said yes. And although you, through Professor Abrahams, you were given a chance to sort of backslide from that a little bit later on, which you did well. It's the only things you want to concede in an oral argument are things that you really have to concede, that you would look foolish not conceding. But that wasn't one of them. There were major arguments in support of your position that still would have been potential winners, some of which you got into later on. So I thought that was a tactical error. And I also, this is a closer call, and I'm not sure all the judges here would agree, but I think it's a mistake to waive rebuttal unless you feel absolutely sure that you're winning. You can't always tell from the questions judges put where they're coming out. Judges will often put questions contrary to what they're thinking just to test their own position and see whether they're on the right track. And a rebuttal is an opportunity to at least reestablish with the court maybe your strongest point, or maybe your adversary has done something that allows you to give a zinger. I just want to comment. I don't have time to comment on everything, but I want to comment on that one point that my adversary made because I think it shows the poverty of their position, and here's why. So it's an opportunity that shouldn't be foregone. Having said that, I mean, you had terrific presence. You answered most of the questions extremely well. I don't want to overstate these two quibbles. Speaker number 2, you had a very tough position. I thought in some ways the hardest position legally of the 4 positions staked out here, and obviously, as you can see from the result, we all thought you acquitted yourself very well. My one quibble with you would be you were a little bit too much of a monotone. It is true that judges are boring people by lot, by nature, but you more than met us. In all seriousness, a little more animation is probably a good thing. You never want to, in an appellate court, act the way you might before a jury. You don't want a stump speech. But you do want to convey, if you will, the passion that lurks behind whatever your position is. In any case like this, there are emotional aspects on both sides that are going to affect how the court rules. A strong passion for free speech, a strong passion for protecting children. These are not, commercial issues, and one needs to express a little of that passion. On the third speaker, your strength was also, I thought, perhaps to a much more limited extent, your weakness. You obviously knew every case known to mankind. Although I have to point out to you that, although you made a point about there's been no such holding in 250 years of American jurisprudence, but there hasn't yet been 250 years of American jurisprudence. I think about 30-something. But but I think judges want to know that you know the law, that you're familiar with the cases. But remember, this is the Supreme Court. We decided those cases. We're familiar with them too. And the reason we granted cert was because we thought there was an issue out there that was not fully decided by our prior decisions. So I think you need to respond to questions not just by citing past precedent, but by giving logical reasons for the position you want to take. Having said that, you were very impressive in your knowledge of our past precedents. And the fourth speaker, I felt in fairness, having found quibbles with all the otherwise remarkable speeches by the three other advocates, that I should come up with a quibble with you, but I haven't yet come up with one. But I'm working on it. Anyway, I thought you were very good. So.
Thank you, Judge Rakoff. Judge Rakoff and I have both indicated what a pleasure it has been to participate in this competition numerous times. I probably have better reason than he. He really works close by. I live in one of the genuine Sweetwaters of this world in central Pennsylvania. So being able to come out here to the big city from time to time has been great fun. Being with all of you is always great fun. Though I must admit, 2 years ago, the fact pattern involved litigation over a sex toy, and I'm beginning to wonder a little bit after the fact pattern for this year, just where you're going next year, and whether I'll be allowed to come when I tell my wife that I'm invited. But in any event, Dean Matasar has links with the Third Circuit, where I sit, as does Judge Rakoff. The dean was a law clerk for one of the greats of our court, Judge Max Rosen, with whom I had the great privilege of serving in the latter years of his life. And I cannot help but observe the remarkable job your dean has done here at this school. I know you all know that. I know you're aware of it. My first visit here, there was no new building. My first few visits here, there was no new building that was occupied. And to have watched just in my relatively short history with this school, the progress that has been made in that regard is no small tribute to the dean. And I commend him, and Max would be very proud. So, Dean, if you could follow up, too, on some of the performances, excellent performances we've seen here this afternoon.
Thank you. Mostly, I want to do some thanks to people because my colleagues here who are far more engaged in the real honest-to-God practice of law and watching real honest-to-goodness lawyers all the time. My hats are off to my colleagues on the bench. These panelists who are here are doing an extraordinary service to our profession by giving so generously of their time year after year, and not just at New York Law School, but really throughout the country, on being able to help aspiring lawyers learn the craft of being a great lawyer. And so to the two Justices Smith on our panel, to Justice Rakoff and to Professor Abraham, my hats are off for finding a Sunday and finding it in your hearts to be with us, to share your incredibly deep knowledge about what it means to be a great lawyer. I think often we learn best by example. And within this panel, we see many of the different things that make up great judges in the country. From the quiet but perceptive nature of our Justice Smith at the end of our panel, to the wit and wisdom that we've seen from Justice Rakoff and to the sort of wisdom, wit, and incisive questioning of Justice Smith in the middle of our panel, and of course to Justice Abraham, who always listens so carefully and finds where the place that the knife has to go and then inserts it so cleanly. I just want to thank all four of them for providing that guidance and the different styles that you're going to face. The one thing I think it's safe to say is you won't find many judges that ask mean questions as I was doing today. It's a law professor's game for me. I don't teach that often, and so it's fun for me to come back and play law professor while I'm here. And I want to thank members of the panel for giving, or the members of the moot court board for giving me a chance on a yearly basis to pretend again that I'm doing something useful in my teaching life. To the students who are here, I don't know what you do on Sundays usually, but coming out here and supporting your classmates is an extraordinary thing to do. People work hard in the Froessel competition and spend an enormous amount of their free time outside of class reading, writing, arguing, sharing, supporting. That's really indicative of a great community that you're here today to support your classmates and see what the last page of this novel looks like. So I want to thank all of you for coming out, for your families. I know there are some of you who are here today. Thank you for coming and supporting your student in your life, because no one makes it through law school without a deep support system. And I think at New York Law School in particular, what we know is that the relationships that are established between our students and their peers is almost as great as the relationship they keep with their families and those who support them in their lives. So thanks to all of you. And of course our competitors did a great job. I won't share with you any of my little quibbles because they are very, very little. And I think my colleagues have expressed well both their admiration for your performance and the slight and few suggestions they might have to improve it. Thanks for making a really entertaining and enjoyable Sunday afternoon.
Thank you, Dean. In the, again, short period of years that I've participated in this competition, I've genuinely appreciated what I think is the genuine friendship I have struck up with Professor Abraham, who I believe was really just starting as the advisor in this program the first year that I participated. And what has been most notable to me during my time here, brief as it has been on those occasions, is the very genuine, concerned, and sincere mentoring that she does and has done. We had an opportunity just today, a number of us, to be talking about being a law student and being a law student here in the job market, and it is certainly safe to say that she has a deep and abiding concern for every student here, for her students, for your professional well-being, and more. And I have just enormous respect for her, and not only as an academic and as an advisor to this program, but as a person. So it's a delight to be back here again and have an opportunity to participate in this with her. And she, I know, will have something to say to each of you.
Well, I want to give, first of all, thank you. That was far too kind and generous. But I want to thank everybody on the bench. First of all, it's true. I want to echo what Dean Madisar just said. The students benefit so much from your generosity and your willingness to come here on a Sunday and really give them an idea of what judges think and have to say, and what their behavior and their styles and their argument is going to look like when they go before real judges in court. And also Dean Madisar for coming and supporting us. All of these people here have worked so hard, and you know that, and it means so much for them to have you here and acknowledge everything that they've done, and to also get the benefit of everybody's really interesting and well-prepared and thoughtful and challenging questions from the bench. So thank you so much to the whole bench, and I really hope, I'd like to give them a round of applause. And next, I just want to say I'm thrilled to be working with the people who I see are coming through the competition. All four of you did a really, really great job. I can see how much all four of you prepared. I can't see everybody, but I could see you when you were arguing. How much you prepared, how the thought that you put into the way you presented your arguments, your style, as well as the substance, obviously, the cases and the law. I know some of you, I don't know which of the four of you are 2Ls and which are 3Ls, but I do know that whoever's a 2L hasn't really had con law yet. And I know for the rest of you who had worked through the competition who are sitting in the audience, many of you haven't had con law yet. And just teaching yourself con law and the various tests and distinguishing between strict and intermediate scrutiny and what narrowly tailored means, all of that, you've done a fantastic job just overcoming, just making a dent in that really dense material that you've had to really grapple with and be able to articulate in front of the judges over the past few days. So I'm really thrilled. I can't wait to start working with the new team, and I want to congratulate all four of you. A couple of really specific things. As I guess Judge Rakoff said, and it was maybe echoed by somebody else up here on the bench, don't forget that the key to every argument, of course you need to know all the details. You need to be focused on the specifics. You need to know the cases. You need to know the facts. But then the key is persuasion. You're right. You're not up here just to show the judges how smart you are. That's part of it, and especially on moot court. When you're new at this, you want to show them that you know the names of the cases and you can distinguish the facts. But beyond all that, the heart of what you're doing here is to present your case in a way that will win over the court. So, no, you don't want to grandstand, but when you have a case that involves both protection of children and protection of speech, you want to find a way to have that be your theme and to come back to it and remind the court not just that we can't restrict, we can't have a local standard because it might be impractical for Dubroff to be able to actually sell their video games, but what's the Constitution all about if it's not about protecting one of our most fundamental rights? And the ability to express ourselves in this country is something that we hold really dear. And maybe it's the speech that's the most vulgar and the least able to understand why it's important that we really need to set that standard with. And that's part of why we're here. That we have to remember that it's easy to have a knee-jerk reaction about something that's distasteful. But that's why we have the Constitution. And the Constitution is, in fact, a national document, and it protects all of us. So just to come back to those kinds of things, and on the other side also, to remember that, that there may be a crisis, and that sometimes we have to step in, a town has to step in, and do something to protect the children, because what's law for if we can't protect our citizens? And, to come back to a theme of something that will grab the court. So remember, it's not just all of the details and showing how much you prepared, but to use all of that in the course of being persuasive. And that's what we're going to learn a lot on moot court. We'll have a lot of opportunities to practice that. And you've all done that in moments, but we're going to really hone those skills and do it well. You all handled very, very dense, complicated legal issues and crazy facts very, very well. And you responded to questions, really well, did well on your feet. It's tough, and I know you're all exhausted. So that's all I'm going to say for now. I'm thrilled to be working with you, and I really look forward to getting to know all of you. Thank you so much.
I am certain that you are all exhausted. It's been a long haul for you, and I also know that this event is followed by, for the participants and the members of the moot court board and some others, a dinner, which I believe also includes drinks. So the last thing I want to do is be the person standing between all of you in the bar. I would like to emerge unscathed from this visit. Just a final thought or two. Your appearance before an appellate panel, and this is also true most of the time before a single judge. As Jed knows, I used to be a real judge before I went on the Court of Appeals. But especially with appellate panels.
You hold yourself in retirement.
there's a clock, and the clock is running, and you have a limited amount of time, and you need to use it very effectively. And as Professor Abraham said, several times she used the term a theme. Have a theme, or several threads of a theme to which you adhere and to which you will return, notwithstanding the exasperating interruptions you're going to get from those people in the black robes there throughout the course of your argument, at least if you have a hot panel, and I think this was a hot panel today. That is the only way I've ever been described as hot, as a matter of fact, I realize. But so use that time effectively. Use it not only effectively by way of your persuasive approach, but also through candor and honesty, representing on those occasions, uncomfortable though they are. If you don't know an answer, you say it, and you say, may I get the answer if it's readily available at council table, or you'll supplement later on. The subject of concessions came up during the course of our discussions, and concessions can be, in certain circumstances, very effectively made, again, within the context of intellectual honesty. A panel really does appreciate where there is a demonstrably weak position or argument where you're willing to concede that one to go on to something that is more sound and more persuasive. I think you all were responsive to the numerous questions you received from this panel, and you're to be congratulated for that as well as for other reasons, for all four of your performances here. Courts are busy. Judges are busy. The question or the point was made, I don't know what you judges normally do on Sundays. Well, I know what I normally do on Sundays, although it's not usually Sunday afternoons. I'm usually working. It is literally a 7-day-a-week job. And I say that not to complain about the work of the court, but to put into context your case and your argument. It's not to minimize it. It is judges are busy people. The time limits are there in recognition of how much there is to do, so use it effectively. Always use it recognizing the very finite quality of the amount of time that you've been afforded. And you'll do well. So I thank you all. I thank you for the invitation again. I thank you for the opportunity to be here at New York Law School and with the Froessel community that I've gotten to know a little bit in the last few years. We thank you very much. Congratulate all advocates and the winners of the tie. And with that, I guess we will adjourn the proceedings.
Oh, you don't have to.
Go ahead.
Okay.
Or we can leave and, I don't know, do you want to stay? We can walk out.
I'm going to give out the awards and stuff.
Okay.
Stay if you'd like.
We'll officially walk out and then some of us will come back.
Okay, sure.
We'll do our compass walk.
All right.
Certainly didn't mean to dismiss you.
Oh, no, no, no. That's okay.
Thank you. I'll be seated. It's pretty difficult to add anything to what Dean Matazar said about the final round bench. but I just want to echo everything he said, and we do owe them a debt of gratitude for being here and taking their time and giving such thoughtful commentary to everybody that's here. I hope we all took something from that. I know I certainly did. So what we're going to do now is the fun part. We're actually going to hand out our awards and extend an invitation to all of our new members here. We might as well just go ahead and start with the awards. Okay, starting with the awards going to the best briefs. We're going to start with the best petitioner brief, and the award winner this year is Ms. Stephanie Scalo. And now for the best respondent brief. The best respondent brief goes to Sarah Garrod and Lynn Cho. Great. And now for the best team. Our best team this year goes to Mr. Brian Dolan and Ms. Lauren Ellisberg. And now for the best preliminary round oralist, who had the highest round scores for the first two rounds, Mr. Ian Thomas. We also have a sort of a mixed award. We recognize 6 individuals who we thought exhibited just made an impression on everybody with their written and oral advocacy skills. It's called the Morris Orland Award, and we extend that to 6 individuals on the team as well. Our first recipient is Mr. Justin Ashenfelter. The second one goes to Mr. Nick Tambone. And the third award goes to Mr. Aaron Lund. Next is Mr. Francisco Vasallo. Next is Mr. Adam Cohen. And the final award goes to Ms. Gretchen Jenkins. And now we're just going to go ahead and announce the rest of the members who are going to be the new members this year for the 2010-2011 New York Law School Moot Court Association. First, already introduced, is Mr. Adam Cohen. I'll just ask you to stand up here with us. Next is Miss Alexa Silverman. Next is Miss Elijah Young. Miss Amanda Ross. Mr. Aaron Lund. Mr. Abraham Baxt. Mr. Benjamin Burge. Miss Beulah Chow. Mr. Brian Dolan. Mr. Christopher Binns. Mr. Daniel Costello. Mr. David Romerman. Mr. David Sabors. Mr. Ethan Wishnick. And Mr. Francisco Visayo. Mr. Gaurav Dave. Ms. Gretchen Jenkins. Ms. Harley Tenson. Mr. Ian Thomas. Ms. Joanna Wine. Mr. Joe Schneiderman. Hey. I like that. All right. Mr. Justin Ashenfelter. Ms. Lauren Ellisberg. Mr. Lawrence Ziegelbaum. Ms. Lynn Cho. Mr. Michael Anslow. Mr. Nicholas Tambone. Mr. Nikhil Pandey. Ms. Nyasha Foy. Mr. Rene Dubois. Mr. Richard Geller. Ms. Sarah Gerard. Ms. Shannon Hagan. Ms. Stephanie Scalo. And last but certainly not least, Mr. Steve Cohen. And that is everybody. So this is the 2010-2011. That's it.
That's it. Thank you guys so much for coming. We appreciate it. So thank you very much. Please stay.